Okay, I'm Karen Barham. I'm a consultant at Moore Barlow. I am a solicitor, but I practice exclusively as an all issues mediator and a parenting coordinator. I'm qualified to see children in mediation, and I'm a PPC supervising other mediators. I'm a member of Resolutions DR Committee and the Family Procedure Rule subcommittee looking at early resolution and particularly the changes to the rules that came in April of last year. I am a believer that many can be assisted where it's safe and appropriate away from court, and that work continues. I'm delighted that we have two academics with us today for this presentation. Dr. Rachel Blakey, who is an assistant professor at the University of Warwick and researches family mediation and family practice particularly. She has an upcoming book which she's going to tell us about, Rethinking Family Mediation. She's considering the changing role of family mediators and particularly their role to assist families where there is no legal support. She has also been co-opted onto the board of directors of the Family Mediation Council, which is a term for 3 years. But as I said to her this morning, it's a little bit like Hotel California. Once you're let in, you're not allowed out. So we're enormously grateful to her for her contributions generally, as we are also to Dr. Charlotte Bendel, who is an associate professor at law at the University of Birmingham, specialising in a range of family law related matters. Her current research is considering how best to support grandparents who seek contact with their grandchildren, particularly where there has been a family breakdown and fragmentation. And her particular focus is the potential role of mediation in that space. Welcome to you both. I shall move directly to ask you to present your sessions, if you'd be so kind. And as I say, I shall be capturing questions as we go, and then we'll take questions towards the end and hope that we try and cover everything. Rachel, over to you.
Yeah. Hi, everyone. Need to kind of preempt it by just apologizing for a raspier voice than I usually have. I had the fantastic timing of getting a cold on the weekend, and then 5 hours of teaching yesterday did not help. But I have a voice, so we'll make do with what we can. My slides should be on your screen, and what I want to talk to you today about is just some of my research about how mediator practice has potentially developed over time in a way that we haven't always recognized or openly talked about. So as Karen mentioned, I do have a book on all of this coming out in just under a month. It's at the end of February, called Rethinking Family Mediation. Thanks, Charlotte. So it is about seeing how exactly, as I mentioned, the role of the mediator has developed over time. So I'm looking at policy developments, but also theoretical underpinnings of mediation, what's changed there, alongside some qualitative data that I'm going to discuss in a minute. And then there's a bit of a broader discussion towards the end as well about external factors, such as the regulation of legal services more generally, and numbers of people entering and leaving the mediator profession and so on. But what I want to specifically spend my 15 or so minutes on is the role of the mediator themselves. So what I'm really interested in with my research is what is the role of the family mediator specifically after LASPO? So how has the role of the mediator changed over time compared to the 1970s, the 1980s, when mediation was being rolled out? What do we now expect mediators to do? What are mediators allowed to do? And what do mediators perhaps do that we haven't openly recognized yet? Now, my work isn't necessarily saying mediators should have this really broad role and they need to be doing this or that, but I'm saying that there have been developments, and it's the lack of recognition that is more of a problem. And the way I tried to conceptualize this is by saying there's been a transition from a limited to flexible mediator practice, or from a limited archetype to a flexible archetype. So I want to talk to you about what that means, and then some kind of evidence in my data, particularly in light of legal norms. So just to provide a very quick overview of what data I collected, this is all based on interviews with family mediators, 17 family mediators from a few years ago. I did also analyse a variety of codes of practice in England and Wales right before that. So it was a purposive sample, which means we're picking the sample to try and reflect a broader range of backgrounds, experiences, or so on. So probably the most important characteristic within the sample is professional background. So I obviously interviewed I selected mediators depending on whether they came from a legal or therapeutic/counselling background. What was quite interesting is when I looked at the data as a whole, there were quite a number of mediators who actually had both elements, and these were usually lawyer mediators who'd then gone on to do some kind of therapeutic training or therapeutic work. So that's what I mean by the hybrid mediators in that table at the top. But there was a general kind of even split between lawyer and therapeutic mediators. The other important characteristic within the sample, I think, is also whether the participant conducted legal aid mediation. And 9 out of the 17 did, and 8 didn't. What's really interesting is that 5 of those 8 who didn't provide legal aid mediation had done in the past, but when LASPO came about in April 2013, they either very quickly stopped or they stopped within a year or two after. So that's the data my work is based on. Before I go through some excerpts from the interviews, though of course there's not many in 15 minutes, it's worth us just talking about what I mean from that limited to flexible archetype transition. So if we look back to the definitions of mediations from as early as the 1970s, but even ones today, mediation is all about helping parties to reach an agreement. So that's really the foundation of mediation, that the parties themselves have decision-making power at all times. And this means there are 2 theoretical strands to mediator practice, and specifically limited traditional mediator practice. So as we all know, mediators are expected to be neutral or impartial, if that's the term you prefer. You're not there to act for either side. You can't appear neutral. You have to be free from bias. The other element is then facilitation. So a mediator is there to facilitate discussions. This terminology is generally cited as coming from work by Leonard Riskin in the 1990s, and he proposed that mediator behaviours could be plotted on a continuum ranging from facilitation to evaluation. So facilitation is, of course, those behaviours that are more focused on helping the parties settle, whilst an evaluative action is intended to direct some or all of usually the outcome. I know some mediators don't like the term evaluation. There's often this discussion that we don't have evaluative mediation. So you could also swap the word for something like directive instead, and it would mean the same effect when we're talking about Riskin's theory. The main thing to note is that Riskin said mediator behaviours were on a continuum. So facilitation and evaluation, or direction, were 2 interconnecting strategies. But the traditional understanding of limited mediator practice adopts a very binary view, and it puts this big cross right in the middle. And that means limited mediators are very much confined to purely facilitative behaviours. And this, of course, largely comes down to the way we understand mediator neutrality. We see mediator neutrality or impartiality as very absolute, something you shouldn't go against at any point. Now, this limited conceptualization, I think, made a lot of sense, and to an extent it still does today. If we think back to family mediation in the 80s, 90s, and so on, most clients had access to a lawyer and continuous legal support. So that meant this right side of the continuum, that evaluation was provided by another professional, and it could even go to then more extreme evaluative behaviours, right, such as partisan advice. Today, though, for many of you here, this model is really unworkable, and some of you will have clients who no longer have a lawyer, or if they do get legal support, It's more of a pay-as-you-go service, or a one-stop kind of one bit of advice at a time. They only go and get advice at certain points of the dispute. So this means that the traditional kind of binary distinction between evaluation and facilitation isn't workable, isn't realistic in a lot of family disputes after LASPO. And this is where the demand has come from in terms of mediators doing more. And we often hear this word of mediators becoming more flexible. So if we think about the flexible mediator, or the flexible archetype, this isn't the opposite of limited mediator practice. To me, the flexible mediator is more about what mediators can do alongside that more limited role. So they still assist, they're still neutral, they're still focused on giving information, but they balance those much more facilitative tasks, with evaluation. So our family mediation codes of practice explicitly permit reality testing, predicting court outcomes, and those actions can sometimes be used in a way that guide parties towards a certain discussion or a certain outcome. And that does bring into question how far we can say that action is 100% facilitative. Again, I'm not saying that mediator evaluation, the flexible mediator, is this unconstrained, unfettered being. I think mediators are really well skilled in knowing kind of how to act within their remit and what's appropriate. They, of course, still can't act like a judge. They can't advise like a lawyer. Though there is a lot of academic commentary on whether the distinction between information and advice is actually realistic. To what extent is it a bit ambiguous? The question, of course, is then, how are mediators navigating this more flexible conceptualization? How is a mediator neutral, but at the same time reality testing or taking appropriate steps, as the FMC code of practice says, when there is some kind of power imbalance? So if we move on to some bits of my qualitative data, the interviews, I think the main thing I can point to as evidence that we have this more evaluative role, and one that a limited conceptualization perhaps just isn't realistic, even 30, 40 years ago, is that the mediators I spoke to didn't see themselves as idle third parties, because what would mediation provide if the mediators did sit there and not provide anything beyond, a purely facilitative approach? And I asked all the mediators I spoke to, what would they do when they were met with a power imbalance, some kind of difficult dynamic? And no one said, oh, well, I sit back, I let it happen because I'm neutral and I can't do these kind of things. That's not within my limited role. They all felt they provided some kind of what was an evaluation, even if they didn't recognize it, that promoted a settlement of a specific quality. So Lauren really captures this really well. She was a therapeutic mediator. She'd been a mediator for decades at the time of the interview. And she was talking to me about a co-mediation case she was doing with a trainee mediator. And she said the trainee mediator wasn't being proactively involved in negotiations. The parties would agree something and she'd just go, okay, moving on. And for Lauren, that raised a lot of red flags. So she said she really didn't seem to quite get it. I kept having to raise it and she decided not to carry on with the mediation, which I think was a good thing. She just had a blind spot. She just thought an agreement was what we were looking for. It's the quality of agreement. Yet we're not making judgments, but you can see what I mean. Whenever I present this, I always say, I wish I'd asked her. Obviously, these are not the samples' real names, but I wish I'd asked Lauren what she had meant. But we have to deal with the data we have. To me, what's really interesting is that Lauren criticizes the trainee mediator for glossing over issues, not scrutinizing enough. She expected the trainee to do more, to be more evaluative than that limited facilitative image or role suggests. So the trainee was seeking an agreement, but to Lauren, mediation was about obtaining an agreement of a certain quality. So a big question for us is, how are mediators determining that quality, and what what are the dominant rules of thumb standards that we're using. You'll all think of some off the top of your head. Child welfare is, of course, a really big rule of thumb or standard, and that's been discussed a lot in previous research, like the Mapping to Pass project. But what was really interesting with my interviews is how was the prominence of legal norms, or the preference or use of the sample to use legal norms to provide this quality agreement. And I think that does raise questions. I know Charlotte will be discussing kind of the role of the law in relation to mediation, as well, about quality. There's a big question as to whether we think this is a suitable and appropriate development as well. But to provide a bit more evidence of this, so you don't just have one quote, there is this idea I talk about in my work called mediating in the shadow of the law. And I'm sure you've all heard of the phrase the shadow of the law. And there's obviously a concern that in mediation cases now where people don't have continuous legal support, the shadow of the law is significantly weakened. Mediating in the shadow of the law doesn't mean a mediator is performing the exact same role as a lawyer, because they're not one. But they are using and applying legal norms in a way that means the shadow of the law becomes more prominent than what it would have been otherwise. So Michael, who was a lawyer mediator, says, I do, wherever possible, give as much general advice as I can, advice that will help move them to a position. I'm probably one of those mediators who will give more advice. There are some, I think, who will just let the client say what they like and not really control it enough. Now, Michael is perhaps a very extreme example of this mediating in the shadow of the law. So he was one of two mediators I spoke to who specifically used the word advice to explain the work they were doing, although the other mediator spoke about it more in terms of tax advice, pensions advice. This does raise red flags. I'm sure for many of you, I look back at it and think, how far is this actually an appropriate thing for a flexible mediator to be doing? But what's clear is that Michael felt the law really guided his mediation sessions and really helped parties reach a certain quality agreement. To provide some more, I guess, standard examples, what was more common within the sample of 17 mediators was just a use of legal norms in general. So quite a number of mediators would refer to specific legislation. David, who was a hybrid mediator, said he would help the parties find a solution that falls within Section 25 of the Matrimonial Causes Act. He was one of 5 mediators who specifically mentioned that legislation. Others referred to Schedule 1 of the Children Act, for example, with financial awards. What was very noticeable is that mediating in the shadow of the law seemed more prominent when mediators were dealing with financial or property arrangements rather than a child-related matter. So Jessica specifically says, the law is always involved. Obviously, the financial cases have quite a heavy weighting on the law. So there is some evidence that these more evaluative actions perhaps become more visible in the financial property remit. And this is a really nice comparison to what Charlotte will be talking to you about with child-related disputes. But nonetheless, I think Mary really captures what the sample felt, that I think it'd be wrong not to tell them what the law says. And of course, that can be just informing, but if we're informing in a way to guide certain quality settlements, that is not how we've envisioned limited mediator practice. I am already over time, so it's just kind of a summary of 2 key issues in light of all of this. Obviously, there is a question of whether legal norms or whatever norms mediators are applying are being used correctly. But I think the bigger one for all of us is whether we think this is appropriate or not. So is this actually evidence we need to distinguish the roles between lawyers and mediators even more, try and really create a distinction? I'm a bit more apprehensive of that response because I think hybridity is a very natural element of family law practice. We've seen all different types of family law professionals becoming more hybrid, becoming more legal when they weren't, becoming less legal when they weren't as well. So I do think part of this is a natural evolution. I think we forget that mediation is actually a really young profession and it's still finding its feet. But then it's worth us having more open discussions about this, what kind of legal roles mediators are providing, to know then how to regulate it going forward. But that's it. That's all I wanted to talk to you about. Thank you very much, and I'll pass it over to Karen and Charlotte.
Rachel, thank you. I've noted some questions of my own, and questions are beginning to come in, which we'll take at the end. Not only if we're asked, are you a flexible mediator, that doesn't just require us to go to yoga or Pilates, but the content there, and certainly got me thinking about the evolution. And I think that nicely segues into Charlotte's presentation in terms of the continuing evolution of this discipline, and actually where it may go, and where it may assist parties, parents, wider family, and the sort of growing use of mediation and its potential. Charlotte, over to you, if we may.
Thank you so much. Just bear with me for 1 second whilst I share my screen. Okay, so I will also start, I'm afraid, with an initial word or a warning about my health. Like Rachel, unfortunately, I also have a cold and a cough. I'll try not to cough at you to the extent that I'm able. Anyway, okay, so I'm going to be talking today about my work with Dr. Samantha Davey at the University of Essex, which relates to grandparent-grandchild relationships, and particularly the way in which those relationships can best be promoted and protected in the event of family network breakdown. And we've recently been conducting some empirical work in this area. I'm going to start by talking today about the background to that empirical work before just explaining briefly at the end where we have got to with it. I'll warn you in advance, we still have some analysis to do, but yes, it's a bit of a work in progress at the moment. Okay, so as a starting point then, something I'd really like to stress is that grandparents perform a really significant role in terms of their grandchildren's lives. And we have a poll that tells us, in fact, that as many as 40% of UK grandparents over the age of 50 have provided regular care for those grandchildren. And yet, we argue that the legal frameworks within England and Wales are simply not doing enough to recognise this really important role that grandparents can perform. And instead, that what they do is that they emphasise children's relationships with their parents and they prioritise that. So we've been particularly thinking about how perhaps stepping outside of those legal frameworks, particularly via mediation, can help perhaps to reinforce the connections between both grandparents and grandchildren, but also the grandparents and the parents themselves. So we conducted some initial investigation into this, which was paper-based, and we published it in an edited collection, which you'll see the details of on the slide. And in terms of that chapter that we wrote, we suggested again that when it comes to these legal frameworks for child arrangements, they appear to have been prioritising what we call the nuclear family. And in saying this again, what we're suggesting is that they've placed more importance on the child's relationship with the parents, with the mother and father, than perhaps with other people. And this, we argue, is in various senses. So the first way in which we argue that the law doesn't place enough importance on children's relationships with the likes of grandparents, for instance, is that grandparents do not enjoy automatic leave to commence legal proceedings in England and Wales in relation to obtaining contact with their grandchildren. So instead, they are required to apply for that leave for contact. And the courts, in deciding whether they're going to grant that leave to a grandparent, for instance, they have various considerations to take into account under section 10(9) of the Children Act. And those considerations include, for instance, importantly, the wishes and feelings of the child's parents. And there is some debate in terms of how much of a hurdle this requirement of applying for leave for grandparents, for instance, poses. And Jonathan Herring actually doesn't seem to think it's much of an obstacle. He seems to say, well, I think there'd have to be pretty good reasons to deny grandparents that leave for the courts. But nevertheless, we argue that this requirement to apply for leave is at least a symbolic hurdle for grandparents, and really signifies their subsidiary status compared to parents. Actually, in terms of this leave requirement, as I say, we've conducted this empirical work. I think we had some quite mixed accounts in terms of how much of a hurdle actually the leave requirement was. Okay, so in terms of a second respect in which we would argue that the law is prioritising relationships with parents as against the child's important relationships with other members of their network, let's assume for a moment that the leave is in fact granted. Also, in terms of obtaining the child arrangements order itself with contact, grandparents also sit, we would argue, pretty uneasily in terms of the legal framework. And that legal framework really emphasises genetic connection, but only in terms of parents and not also in terms of grandparental genetic connections. So the courts have been much more willing to award contact to fathers or indeed to mothers where it's appropriate to do so. And in fact, as I'm sure we'll be aware, since 2014, there's been a legal presumption that unless the contrary is shown, actually the involvement of both parents in the child's life will further, again it's presumed, that child's welfare. But there is, of course, no such presumption when it comes to the likes of grandparents. And in many cases, there can be practical ways in which grandparents can nevertheless get that contact with their grandchildren. So it might be, for instance, that their child, the parent, gets that contact and the grandparent can then see the grandchild when the child has that contact with their parent. So as I say, that can be a practical way by which grandparents can get that contact, but of course it's not always possible or feasible. It could be, for instance, that that parent is not awarded direct contact, so perhaps the child won't have contact with the parent for that reason. It could be that that parent is not seeking that contact with the grandchild, so that might be an issue as well. Another issue we might find is that that parent might, in fact, unfortunately be deceased. And actually, that's something we had coming up quite often in terms of our empirical work that we've done. This scenario of one of the parents, unfortunately, having died and what the implications of that can be for grandparents. In any event, so again, whilst there can be these practical ways around this issue, nevertheless, this reliance perhaps by grandparents on this parental route again signifies the importance that the law places on parents as against grandparents. And a third way that we argue that grandparents are disadvantaged in terms of the law is in terms of enforcement of court orders. So even if grandparents get that contact, if it doesn't work out, then enforcement can be a real issue. We appreciate that enforcement is an issue across the board, but the suggestion is, in terms of the case law, I have a case on the slide here, Re B, for instance, which really suggests that this is a particular problem when it comes to grandparents. So in all three of these respects, then we would argue the law appears to evidence this parental preference favouring the nuclear family over other perhaps network members of the child, such as grandparents. But as against this, Dr. Davey and I have argued that we would prefer a more relational approach, recognising the wider network of people such as grandparents that can play really important roles in children's lives. So I'd just like here briefly to clarify, when we use this term relationality, what do we mean? So the idea behind the relational approach is this thought that the very nature of who we are essentially is determined by our interactions with others, with our relationships operating to shape our lives. And children, like us all, are not islands as such. Even genetically, they're a product of not only their parents, but also their grandparents. So really, really important figures within their lives. Moreover, in terms of when those children go on to interact with the world, children do so through the lens, I suppose, of their caregivers. And as we've already established, grandparents can perform really important roles in terms of that caregiving. So they're really significant there. And family caregivers can not only provide the language that children use, the ideas that they form, and give them a sense of who they are and where they belong. And as those children grow older, in fact, grandparents offer really important knowledge of their family, of their roots, of themselves and where they come from, and also really significant emotional support, particularly, of course, when parents' relationships break down. And indeed, it can work the reverse way as well. Cornhaber, in fact, acknowledges that every time a child is born, a grandparent is born as well. So grandparents' sense of selves, their welfare, their understanding of themselves can be impacted as well by the relationships that they have with their extended families. So we argue that these relationships are really significant, and particularly where a grandparent has performed a caring role within a child's life, we argue that that should be given recognition and that an ongoing relationship between grandparent and grandchild should be facilitated wherever possible. That said, again, we have some skepticism about the law's capacity to accommodate this kind of approach within England and Wales, and that is where, in our minds, mediation hopefully might be able to come in. So returning back briefly then to those legal frameworks, we all know, right, under Section 1 of the Children Act, when the court is determining a question around a child, whether they should have contact, who they should live with, that child's welfare is to be the paramount consideration. And Jonathan Herring says, okay, well, when it comes to the application of the welfare principle, typically what the courts are doing are following a course of action which best promotes the interests of the child, notably viewed as an atomistic entity. So he's saying, well, essentially, when we're thinking about the welfare principle, largely we're focusing specifically on that child separately. However, he does also say, well, there is some prospect to look at this welfare principle in a broader kind of way. So he says, well, we can adopt a broader approach to this welfare principle, based, he says, on the idea that we can only really get a sense, I suppose, of the welfare of the child once we've acknowledged the relationships within which that child is situated. So this idea that the kind of rights and interests of children are bound up with those of the people that care for them. But the focus of Herring's work, though, is predominantly on the parent-child relationship, so how to account for the rights and interests, specifically of parents. And Dr. Davey and I have argued that actually we think it would be quite challenging to extend that kind of broader approach that Herring is talking about to include the likes of grandparents. And a dilemma is posed, particularly in terms of the fact that when we think about litigation, of course, what we're requiring ultimately is that the matter will be adjudicated one way or another. So there's this kind of win-lose dynamic to that litigation, which makes this whole situation problematic. And what it means is, of course, the courts are in a position where they're having to balance out these independent interests of both parents and grandparents, and they're faced potentially with real difficulties when they're weighing up interests that point in completely different directions. So Dr. Davey and I have argued that we feel that the grandparent-grandchild relationship would instead be better promoted and protected outside of this legal system. And we argue that mediation, in fact, carries several advantages in this context. So first, in terms of its less adversarial, less adversarial, less confrontational nature. Mediation, of course, we hope anyway, fosters better cooperation between the parties involved, and mediators can operate to support those parties in finding their own solutions rather than having a solution imposed on them by the court, right? So both sides are encouraged to negotiate and to compromise and to find an arrangement that everybody can live with, which in itself can mean that arrangements are more likely to stick in the longer term than again being imposed from above. And the more collaborative environment of mediation holds greater potential to reduce hostilities between parents and grandparents and to build bridges between the two, in contrast to those nasty, those aggravating effects of the court system. And this is particularly important given that, of course, the relationship between the grandparent and the grandchild is dependent on there at least being a level of civility and cooperation between the grandparents and the child's parents. We think that there's another advantage of mediation when we're coming from this perspective of relationality that I mentioned a moment ago. And this is in the sense that we argue that mediation seems to suggest, to present opportunities to break away from some of the problematic norms that underpin family law. And this is given, of course, that the substantive law within the context of mediation is not determinative of what comes out of that mediation. Of course, now this is speaking to what Rachel was talking about earlier. Of course, we can have this aspect of evaluation, as she mentioned, coming out of Riskin's model. So we do have perhaps this aspect of reality testing in terms of mediation, but where, of course, people are deciding their matters through mediation, again, that law is not in itself dispositive of the matter. So where people are resolving their matters through mediation, it's therefore possible, we would argue, to opt out of legal norms. And they can reach outcomes that can be that would be unlikely, I suppose, to be favoured by the law and may not even be possible within the context of that law were the matter to be decided by the courts. And this again means that arguably mediation presents this possibility to break away from that nuclear family model, which has seemingly been prioritised in the context of the law, and to accommodate wider familial relationships such as that between grandparent and grandchild. However, importantly, there's been limited empirical evidence to date around grandparents' experiences of engaging with mediators or indeed the court process. So this is where we come in. Consequently, between late 2023 and mid 2024, Dr. Davey and I conducted some in-depth interviews to build an evidence base in this area. And we've conducted a total of 50 interviews made up of grandparents who have been seeking contact with a grandchild who've gone to mediation and or the court process. We also spoke with family lawyers who have advised grandparents on these sorts of matters. And we also spoke to mediators. And the intention of these interviews ultimately is to try to assess the effectiveness both of mediation and of the legal process in overcoming barriers to contact between grandparents and grandchildren. And indeed, we want to think about both how the law, but also how mediation might be optimized in this respect, albeit that we would, of course, stress that we feel that mediation is potentially a preferable route for grandparents. Now, I was doing so well. So in terms of where we are with the project, as I say, we're currently in the process of analysing our interviews, so I'm afraid I don't have any concrete findings for you today. However, just a very brief word in terms of the point that we've got to in the sense that I'm getting. I have started to develop, I think, some sorts of ideas around where mediation might work in this kind of context and where mediation perhaps might be more problematic. So one context, I think, where mediation can perhaps be successful in this kind of context, or more successful, I use the term successful very cautiously, but can be in terms of shorter term glitches in the relationship between parents and grandparents. So if there's been a shorter term breakdown of the relationship, particularly if there's been some sort of misunderstanding potentially between grandparent and parents, that can be a scenario which it seems potentially could be successful in that context of mediation. Also, if there's been a breakdown in communication, that also seems like a scenario that potentially could be suitable for mediation. Another scenario where it seems that mediation might be helpful is, say, for instance, their child has had a partner who they haven't approved of, and the relationship has broken down for that reason, but potentially that relationship may have broken, the relationship between the child, I suppose the parent, and their partner may have broken down since, and so it then seems possible, perhaps in the context of mediation, to then repair relationship between grandparent and parent. So those are the sorts of scenarios that it seems like mediation might potentially work. Conversely, what I have been finding is where there's been a longer term breakdown of relationship between parents and grandparents. One interview, for instance, described 30 years of dysfunctional relationship. So when there's been that longer term difficulty in terms of relationship between parent and child, where the conflict is very deep rooted, sometimes you've got that sense that potentially it was too late for matters to be resolved by mediation, and that those people were seeking to have their day in court. Anyway, so we'll be finishing up our analysis later in the year. I'd love to come back and speak to you about what we find in due course. But in the meantime, thank you so much for listening. I'd be really interested in any feedback that you might have on the project. Thank you.
Charlotte, thank you. When do you think your findings may be published?
Good question. I'm hoping next year, potentially, we should have a report. I mean, we're hoping to write a book, but as Rachel will tell you, that's a longer term project. So I think that might potentially be the year after again, but I hope we should at least have some findings to report next year.
Okay, well, obviously we have an organising committee for Family Mediation Week, but I would have thought you both coming back and to continue to shed light in this space would be enormously helpful. We have 15 minutes or so for questions, and there are a lot of questions. I think it's unlikely we're going to get through them all. A very quick answer, Sarah, yes, the slides will be available. I'm sure you neither of you have any difficulty with your summaries there being cascaded, which is helpful. On the point of grandparents and support, we have the voucher scheme extended for another year, and of course that voucher is available where there is a child under 18 with a matter that would otherwise go to the court. And so we should all, I think, as mediators and referring solicitors and others, think about the use of the voucher and mediation for wider use than typically between parents. And I know that the Nuffield did some research in what I think we're calling the forgotten 10%, those that are making private family law applications to court that are not parents. And my understanding is that each year that involves around 5,500 applications in England and 300 in Wales, with grandparents accounting for 58% of those applications in England and 63% in Wales. And so this is an enormous area. I think we also know in the work we do that children cannot be loved by too many right-thinking adults, and the loss of potentially an elder, wiser family member at a time of family breakdown it is another loss for a child or children. And we certainly know that it takes a village to raise a child. So really important work and an awful lot that we need to be thinking about and providing resources for people to have assistance. Is your view, do you feel, Charlotte, on balance, that mediation is underutilised in terms of what otherwise would be some of that forgotten quiet 10% that are making their way to the family court in terms of grandparents, and that we really need to think about mediation in this space?
Absolutely, yes. I really do think it's underutilized, and I think the word really needs to get out there about the importance. I think, particularly in light of what I was saying about the position of grandparents in terms of the law, that potentially, I mean, I think. Again, the sense, it's very early days, but a sense that I've got out of the interview data so far is a real kind of sense of powerlessness in that legal context. But of course, in the mediation context instead, there's more of that possibility to break away from that and for everybody to have their say and potentially to come to that kind of compromise, I suppose, within which everybody has an input. So I think in that sense, it could be really quite empowering, I suppose, in that sense for grandparents, and that really needs to be emphasised.
Okay, thank you for that. It also got me thinking in very much in the way that in the Parenting After Parting resources with resolution, we have a booklet helping separated parents help their children. I'm not aware of a similar resource for grandparents. It may be out there. Note to self to add to all my other actions to see if there is something there. And if there isn't, actually, whether we could generate another takeaway along those lines of a resource for grandparents, which may be, the typical sort of message, don't speak when angry, it may be the best speech you ever regret, etc., etc., etc. And I think there's probably a piece of work there to think about that. Okay, thank you enormously. Let's try and get through some of the questions in the remaining 10 minutes or so. We have a question from Marion. Thank you. Thank you to you both for the work that you're doing in this space. Thank you to the academics that aren't here and to all the academics that have gone before you, as I say, to help us learn and understand what we need to know, particularly those of us from a pure legal background. I think probably a question for you, Rachel, relying on risks limiting the theoretical understanding of mediation as a combination between law and therapy. Please comment if you are able to in a couple of minutes.
Yeah, absolutely. I'll keep it short. I'll try and keep it shorter than that as well. But thanks, Marion. I love your work as well. I've read a lot of it. I do think that's a really big thing for us to keep in mind, that there is clearly this demand for family law disputes to be resolved in the law. I think, like Charlotte said, that isn't something we should just accept. We need to think about what family law norms actually are. But with mediation in particular, if mediation is becoming more law focused, or from what we can tell it is, we don't want to lose sight of those therapeutic elements that I think really strengthen mediation and really distinguish it from legal practice. I do think Riskin's continuum has been largely talked about in terms of the legal remit, but you can also have more evaluative behaviours that link onto those counselling or therapeutic elements. So I remember speaking to a mediator years ago, I think at an event Charlotte ran. She felt mediators should be more directive, and we talked about it, but she meant more from that counselling therapeutic side. So I think that's just, I don't necessarily think it's a risk inherent in Riskin's continuum, but the way we're approaching it perhaps is something that's been limited. It is something that just didn't come out in my interview data. It was very much that focus on the legal, which I think links to the demands LASPO has placed on many mediators. But that's definitely something that I think you're right, we need to not overlook, we need to not overshadow those therapeutic elements too.
Yeah, thank you for that. I suppose the way in which the evolution, the mediation offerings have evolved is in response to what we think the clients require.
Yeah.
Should not mean we lose sight of actually what is ethical practice. But I wonder to what extent the mediator's background suggests where they are on that continuum. Question for either of you.
I guess if I start and then Charlotte might be able to come in as well. I think what I found really interesting is that across those various subgroups, even if we say it's a lawyer and therapeutic, they both brought in legal norms. Because it's interview data, it can't tell us how those legal norms are being applied actually in practice. I think that we need observational data for, and that's what we're really missing at present. But as Charlotte will know, it's very difficult to get the grants for those kind of schemes. Getting the ethical approval is very difficult as well for those grants. So until we have that observational data, I don't think we will know. We would assume someone who's been a lawyer for a decade or two will have perhaps more awareness, or have more of a, especially for financial, I think, if they know the parties need to go get a consent order and have it approved by a judge, maybe it's there. But there is way more information about the law out there that individuals use, but also mediators without a legal background would use as well. So I think my answer, Charlotte, might differ, is we don't actually know.
Yeah, I particularly don't actually know because I haven't finished my data analysis yet. I mean, I definitely did get a sense of a distinction in terms of the approach between those with more of a therapeutic background and those with more of a legal background. But it's difficult for me to put my finger on at the moment as to what exactly that is. But actually, I might just be really cheeky and take the opportunity to ask Rachel. I thought it was really interesting in terms of your point about how you felt that the law was more of a kind of guiding framework, I suppose, in the context of property as against children. I just wondered whether you had any notion as to why there might be that difference.
I think part of it comes down to client expectations, and there's been some questions on the Q&A linking to this, so I'll start to summarize some of them. Of, is it not the clients who are determining the level of support? And I think mediators will often say to the parties, well, most of my clients will go to the court for that financial order. There's an expectation of it being in line more so with the law. So I think what the client comes for will really matter. What I think would, excuse me, be really interesting is those cases where they're dealing with both elements, because we know most people, sorry, both of us are coming at the same time. All issues mediation, which only came about in the 90s, is often what's used. So it's a shame my data, I think, didn't kind of undercover that as much. Sorry.
You're doing really well. I think one of the things I took from your presentation, and I often think about this in my own work, is that for the clients, it's not just the destination, it's the journey. And I wonder sometimes those of us from a legal background sort of have a tendency perhaps to jump to the outcome, the destination. The importance for the clients is the journey, and that is perhaps where our therapeutic colleagues hopefully get that balance right. What I also took away is Michael, and I suspect a lot of us sort of sat there and he said, and I give advice and I give advice. I mean, it's the sort of thing that actually, if as a mediator you say advice, you should perhaps get a sort of short, sharp shock from your computer or whatever, because of course we say it's information. And I also know, and I think, Rachel, this is something that you will, perhaps after you've got a few other projects off your desk, is looking at the emergence of the one lawyer, one couple role, and people saying, cracky, what's the difference? We're awash with different processes, people doing different things, what you can do, what you can't do. What clients need is often, is a combination, we think, of some legal advice, some emotional support, and mediation if it's safe and appropriate. But if they're going to work with one single authoritative voice, is somebody to hold them. And I don't know that clients get themselves really caught up about information and advice, although we do very much as professionals. In the remaining 5 minutes, there was a question from Alan. Is the changing public financing of family mediation services, legal aid, the voucher, affecting the structure of the family mediation business and the mode of delivery of services? I think what I would say is probably since you started to conduct your research, we know there have been increasingly the quiet quitters from the legal aid mediation space. Any thoughts there? You may say, well, look, you're in business, Karen, you can answer that. But any sense of the changing models in the way in which people are offering their services in the mediation space?
I think that's a great question, Alan. My data anyway can't comment on the developments with the voucher scheme because the interviews were conducted before that, and the codes of practice haven't necessarily been adjusted in light of any of that in terms of expectations. But I think what obviously was interesting, like Karen was saying, sorry, is that a lot of the mediators I spoke to stopped providing legal aid mediation after the last SPO. So that in itself is a change in the structure. What I found really interesting in my sample, and I talk about this in a later part of the book, is there was a noticeable number of mediators who were, I guess, sole mediators. So they ran sole practices and they were the only mediator, sometimes the only staff member, or they'd have some kind of one or two people working on the administrative side. And the reason I find that interesting is because it's really in sharp contrast to lawyers. When we look at the statistics released by the Law Society and so on, more solicitors are working in-house. So we have fewer law firms, but they're bigger, and definitely fewer kind of individual lawyers. So there's a difference in how the business structures, I think, are changing in mediation and lawyers generally. And I think my data just did show mediators had a focus on the commercial. I think we just assume there is this purely philanthropic reason for mediation. And I think that underpins a lot of motivations why people become family lawyers, become resolution members, go into mediation. But there's obviously also this need to have a viable business structure. And I think that's something we perhaps need to delve into a bit more.
Absolutely. And thank you, Ruth, for your comment about the value of co-mediation, which is a resource, an enormous additional resource where it can be afforded. We've got 2 minutes. Quick question, if I may, for you, Charlotte. In your research, the opportunities for interviewing parents who were refusing contact time with a grandparent, and anything that we might learn from that.
I think there would be a lot to learn from that. We'd love to have some further funding to continue the interviews, essentially, but limited by that at the moment. But yeah, I mean, I think that's a good point of getting the perspectives from all angles, maybe even children as well. You know, where do you end? But yeah, it's something we haven't done to date, but would be interested in doing in the future.
Well, thank you both. We are now with the 1 minute warning. Again, may I thank you on behalf of those that have attended, those that will be watching this, the Family Mediation Council, and the profession generally for the work that you are undertaking and continuing to undertake. We look forward to the publication of books, research, etc. I have absolutely no doubt that you will become a regular feature of the Family Mediation Week. And we're enormously grateful to you for your contributions. And of course, please remember that we have a pool of talent from which you may draw as and when you need it, in terms of mediators of all types, flexible or not, who may be able to assist your research and learnings.
Thank you.
Thank you both. Have a good day, everyone.
Yeah, thank you, everyone. Thank you for coming. Appreciate it. Thank you, Karen. Thank you, Helen.